This week we're going to talk about Chapters 7 and 8. Chapter 7 is Introduction to Tort Law. The principles of tort law pervade modern society because they spell out the duties of care that we owe each other in our private lives. Tort law has had a significant impact on business because modern technology poses significant dangers, and the modern market is so efficient at distributing goods to a wide class of consumer. Unlike criminal law, tort law does not require the tortfeasor to have specific intent to commit the act for which he or she will be held liable to pay damages. Negligence or carelessness is a major factor in the tort liability. In some instances, especially in cases involving injuries caused by products, a no-fault standard called strict liability is applied. What constitutes a legal injury depends very much on the circumstances. A person can assume a risk or consent to a particular action, thus relieving the person doing the injury from tort liability. To be liable, the tortfeasor must be the proximate cause of the injury, not the remote cause. On the other hand, certain people are held to answer for torts of another. For example, an employer is usually liable for the torts of his employees, and a bartender might be liable for injuries caused by someone to whom he sold too many drinks. Two types of statutes, workers' compensation and no-fault automobile insurance, have eliminated tort liability for certain kinds of accidents and replaced it with an immediate insurance payment plan. Among the torts of particular importance to the business community are wrongful death and personal injury caused by products or acts of employees, misrepresentation, defamation, and interference with contractual relationships. Chapter 8 is Intro to Contract Law. Contract law developed as the status-centered organization of feudal society faded, and people began to make choices about how they might order their lives. In a capitalistic system, people make choices about how to interact with each other, and necessarily those choices expressed as promises must be binding and enforceable. The two fundamental sources of contract law are the common law as developed in the state courts and as summarized in the reinstatement or second of contracts, and two, the Uniform Commercial Code for the sale of goods. In general, the UCC is more liable than the common law in upholding the existence of a contract. Types of contracts can be distinguished by four criteria. One, expressed and implied, including quasi-contracts implied by law. Two, bilateral and unilateral. Three, enforceable and unenforceable. And four, completed or executed, and uncompleted or executory. To understand contract law, it's necessary to master these distinctions and their nuances.